Hi, welcome back everyone. And in this session, we are going to discuss about the evidentiary value of public documents. The following are public documents. 1. Documents forming the acts or records of the acts of the sovereign authority, of the official bodies and tribunals, of the public officers, legislative, judicial and executive of any part of India or of the Commonwealth or of a foreign country. And it can also be public records kept in any state of private documents. Now, the following are few examples of public documents. That is, the register of birth and death kept by municipal authorities, acts and records of election commission, records and courts of justice, and records of acts of official body, the deposition of witness or confession recorded by magistrate, or all records of tribunal. Now, comparison between public document and private documents. Private documents. Section 75 defines that every single other document is private. All the private documents are kept in the hands of private people under their very own guardianship. Affirmed duplicates can't offered relating to private archives. Truth be told, the words confirmed duplicate don't emerge in private care. Private documents are not open for in the area to any individual. That is, private documents are not open for in the area to any individuals. Now, method of evidence. The method of demonstrating private archives have been given in sections from 61 to 73. So, the method of demonstrating private archives have been given in section 61 to 73. A private record is one arranged between the people for their standard business exchange and correspondence. Guaranteed duplicates of the private record for the most part can't be taken in proof. Whenever taken, there must be evidence of a unique record. There is no such insurance that it is a private report. The first should be created under watchful eye of the court. So, general rule is that you cannot provide private documents cannot be brought before the court in duplicates. That's the general rule, and it is discussed in private document is discussed in section 75, and the method of evidence is discussed in section 61 to 73. Now, the precedent: correspondence between people, any issue distributed in the paper, books, and so on. Public documents. The term public documents are defined in section 74. So, private document is defined in section 75, and the public document is defined in section 74. All the public documents are kept in some exceptional guardianship of the specialist. Confirmed duplicates of the public documents will be given to any individual requesting it on paying endorsed expense. But this is not available with respect to private documents or documents kept in private archives. Now, public documents are available to review to any individual. And method of confirmation. The method of demonstrating public documents have been given in section 76 to 78. And the method of evidence for private document is from section 61 to 73. With respect to public document, it is section 76 to 78. An open archive is one arranged by a public hireling in release of his open authority obligations. Ensured duplicates of the open record can be gotten in proof and without evidence. Examples: documents shaping the acts or records of the acts of the sovereign specialist, tribunal, etc. Section 77 gives that specific unique open report need not be delivered under the steady gaze of the court. Confirmed duplicate is adequate. That is held in section 77. Now, private document. Any document which does not fall within the purview of public document is a private document. For example, mortgage deed, sale deed, gift deed, lease deed, contracts, etc. And every public officer having the custody of a public document shall issue a copy on demand after the collection of the fee. The copy with a certificate at the foot as true copy is called a certified copy. So, a certified copy will have at the foot labeled as true copy. Now, any public document must have been prepared by a public servant in his official duty. For example, order sheet in a case, judgment, decree, and so on are public documents as they are acts of public officers. But a plaint or written statement is a private document because it is not an act of a public officer. Now, certified copies may be produced in proof of the contents of public documents or parts of the public documents of which they purport to be copies. Now guess it. The court shall presume the genuineness of every document purporting to be a gazette, if the same is kept substantially in the form required by the law and is produced from proper custody. Now, public registers. The following documents may be proved as follows. 1. Act, orders or notifications of the central or state government or any of its department, by the records certified by the head of the department or by any document purported to be printed by the order of such government. And second one, proceedings of legislature by the journals of the bodies or by copies purporting to be printed. 1. The acts of the executive or the proceedings of the legislature of a foreign country by journals published by their authority or a certified copy under the seal of the foreign country. And the second scenario, that is the proceedings of a municipal body in the state by a certified copy of the proceedings or by a printed book published by the authority of the body. Now, documents. Proof of document. If a document is produced in the court as a proof of fact, its execution must be proved by a witness. If the document is required by law to be attested, its attestation must be proved by some witness. For example, 1. The execution of a promissory note is required to be proved in a suit for recovery of the amount due thereunder. The second example, the execution and attestation of a mortgage deed is required to be proved in a suit on mortgage. Sometimes the executants, attestors or the scribe of the document would have died due to efflux of time. It is difficult to prove the handwriting, executions and attestation of the document in the ordinary way. Section 90 of the Evidence Act removes the difficulty in the case of ancient documents. Section 90 deals with ancient documents. A document which is 30 years old is treated as an ancient document in court when produced. The following conditions must be proved for Section 90 of the Evidence Act to apply. The first one, the document must be proved to be in existence for 30 years or more. The second, the document must be proved in the court to be from proper custody. Third, the document must appear free from suspicion. Fourth, this provision does not apply to anonymous documents. The court may presume the following in relation to an ancient document. The first, that the signature and every other part of the document is proper and signed by the person whose signature it bears. Second, it was duly executed and attested by the person by whom it purports to be executed and attested. The presumption to be drawn under this section is, however, in absolute discretion of the court. Now, examples of proper custody. 1. A has been in possession of a landed property for a long time. He produces from his custody deed relating to his property. The custody is proper. The second scenario, A produced deeds relating to the property of which he is the mortgagee. The mortgager is in possession. The custody is proper. The documents must be 30 years old when tendered in evidence. Then only the presumption of genuineness as ancient documents can be drawn. The documents could, however, be produced in court earlier. Official certificates. The court shall presume to be genuine every document purporting to be a certificate, certified copy or other document which is by law declared to be admissible as evidence of any particular fact and which purports to be duly certified by any officer authorized. The court shall presume any officer by whom any such document purports to be signed or certified held when he signed it the official character which he claims in such paper. Now, judgments. A dispute is decided by a competent court. The court delivers a judgment or decree or order. The original or certified copies of the same is a relevant fact. The judgment or decree or order prevents the court from taking cognizance of the suit on the same subject matter. Of course, the judgment, decree or order must have been given by a competent court. The judgment is conclusive evidence as against persons who are parties thereto. The judgment operates as res judicata between the parties in a subsequent suit. The judgment operates a double jeopardy in the subsequent criminal case relating to the same offence. A judgment not inter partes, though relevant, may not be conclusive. Now, judgment in personam. A judgment in personam binds only the parties thereto. It is not binding on a third party. For example, in suit for injunction, second, in suit for recovery of possession, in suit for redemption of mortgage, etc. Judgment in rem. The persons who are not co-nominee in the parties are also parties to it, are also binding. The judgment is binding on everyone. For example, in probate proceeding, in matrimonial proceeding, in insolvency proceeding, etc. The judgment of a civil court would be relevant in a criminal case, but the judgment of a criminal court is not relevant in a civil case. So once again, the judgment of a civil court would be relevant in a criminal case, but the judgment of a criminal court is not relevant in a civil case. Any party to a suit or other proceeding may show that any judgment or decree or order which is relevant was delivered by a court not competent to deliver it, or was obtained by fraud or collusion. Thus, a judgment can be impeached on the following grounds: 1. Fraud. 2. Collusion. 3. Court having no competency. The above objection goes to the root of the matter and can be raised even at the execution stage. Fraud is a deceit exercised by one party on the court and the opposite party. The fraud can be intrinsic and extrinsic to the proceedings. Collusion is a conscious act of both parties to snatch a judgment from the court. A make-believe contest in the proceedings is a collusive affair. When a party to a suit or proceeding puts forward a judgment in evidence, it is open to the other party to avoid its effect on the ground of fraud or collusion. Now, probate and letters of administration. Probate means a copy of a will certified under seal of a court of competent jurisdiction with a grant of administration to the estate of the testator. This confers the right to administer the estate or execute the disposition made in the will. The same can be granted to the executor appointed expressly or impliedly under the will. The application of probate must be made to the district judge within whose jurisdiction the property of the testator is situated, or the place of the residence of the testator at the time of his death. Now, the probate shall be granted only to an executor appointed by the will, which appointment may either be express or implied. For example, A wills that C be his executor if B will not. B is appointed executor by implication. Now, probate cannot be granted to a minor or a person of unsound mind or to any association of individuals. However, it can be granted to a company if it satisfies the condition prescribed by the rules made by the state government. When several executors are appointed, probate can be granted to all of them simultaneously or at different times. The grant of probate may be revoked or annulled for a just cause. The following are the just causes: 1. Where the probate was obtained by defective proceedings. 2. Where the grant was obtained fraudulently by making a false suggestion. 3. Where the grant was obtained by means of untrue allegation of a fact. 4. Where the grant has been useless and inoperative through circumstances. 5. Where the person to whom the grant was made has willfully and without reasonable cause omitted to exhibit an inventory or account in accordance with the act. And 6. Where he exhibited untrue accounts. Now, letters of administration authorizes a person for administration of the intestacy. Now, it will be granted where the executor appointed through a will renounces to accept an executorship within the prescribed time. Where an application for a grant of letters of administration is made, it must relate to the entire will or estate of the deceased. The administrator acquires the rights of the deceased possessed by him at the time of the death. The letters of administration granted relates back to the date of the death of the deceased. The letters of the administration is granted to a person to keep the property of the deceased intact. Now, to the differences between probate and letters of administration. Probate. Probate is a copy of the will certified under the seal of a court of intestacy, whereas letters of administration is an authorization by the court for the administration by a competent jurisdiction. Now, probate shall be granted only to an executor appointed by the will. Letters of administration can be granted to any person when executor renounces to accept the probate. Now, the person appointed by the will either expressly or impliedly is called executor. That is with probate. The person appointed by the will either expressly or impliedly is called the executor. With respect to letters of administration, the person authorized to administer the estate is called the administrator. Now, with respect to probate, the probate establishes will from the death of the testator and render all intermediate acts of the executor valid. And with respect to letters of administration does not render valid any intermediate acts of the administrator. Now, duties of the executor and administrator. The executor is under a duty to provide funds for the performance of funeral ceremonies of the deceased. The executor or administrator are under duty to exhibit an inventory containing a full and true estimate of all the property in the possession and all the debts due from the others. He shall exhibit an account of the estate. The executor or administrator shall collect the property of the deceased and debts that were due at the time of death. Now, the fourth one, the executor or administrator are under duty to pay wages payable to the services rendered to the deceased by a servant or laborer for the period of 3 months preceding the death. Now, liabilities of the executor and administrator. First one, the executor or the administrator is liable for the loss or damage due to the misapplication of the estate of the deceased. Now, the second one, the executor or administrator is liable to make good the loss caused to the estate of the deceased by negligence. Now, report of judicial officer. A judge may put questions to a witness in order to discover or obtain a proper proof of relevant fact. He may ask any question in any form, at any time. The judge may order the production of any document or thing. Thus, there is a wide power conferred on a judge to ascertain as to how the facts actually stand. Now, with that, however, there are certain restrictions or checks for a judge. The power of a judge has been restricted in the following cases. The first one, the judge cannot ask any question which would be improper for any other person to ask. Now, second one, the judge cannot compel a witness to answer any question which he would be entitled to refuse to answer if put by the adverse party. Third, the judge cannot compel any witness to produce any document which he would be entitled to refuse to produce if called for by the adverse party. The fourth, the judge cannot dispense with the primary evidence of any document except in cases exempted. The judge can make a report about the facts elicited on his questions while recording the evidence of a witness. So that is with this section. We have one more part regarding this series, that is a guide to a law of evidence by C. Govind. And thank you for listening. Like, comment and subscribe. Click the bell button so that you get an update when I upload a podcast or a next video. Thank you everyone for listening. Have a nice day. Bye.